Now, as we have read, there are two parties to the contract of agency. One is the agent, another one is the principal. Now, what is a valid definition of an agent? Every person who acts for another is not an agent. He can never always be designated as an agent to the principal. A person does not become an agent only if he works on another's behalf because he gives him advice. It's not only the case. Section 182 explains that to be an agent, the person employed must be authorized to do any act for another or to represent another in dealing with third parties. That means a person who can represent the principal to the third parties, that person can be an agent. And yes, it is very important to know here that a minor person can also be employed as an agent. We know that a contract with minor is a void ab initio. But here in that case, because agent is working on the behalf of the principal and for all the transactions made by the agent, the principal is going to be responsible. So that's why a minor can be employed as an agent. There is a case Harbans Lal Kapoor versus Messer Produce Exchange Corporation Limited. Let's see the facts of the case. The question arose whether Harbans Lal Kapoor was an accounting party or not. The branch office transacted a business worth about a lakh of rupees every year. Kapoor was employed as an accountant by the plaintiff company and his duty was to maintain the accounts. It was held that the courts below were right in observing that Kapoor was the accounting party here, so the appeal fails and is dismissed with the costs. Next, we come to what is the definition of the principle. Section 183 clearly states that a person who is the age of majority and is of sound mind can become a principal. That means one of the feature of being a principal is that the person must have the capacity to enter into a contract, which we have already studied in detail. That means a person should be of age of majority. He should be of a sound mind to become a principal. Next case, a minor cannot act as principal because a contract with minor is always void ab initio. So a minor cannot be act as principal. Reason being, if anything done by any transaction done by agent will make the bound principal. So if the minor would be the principal, he cannot be enforced. So the contract would become void. So in that case, a minor cannot act as principal. This is also clear in the case of Mahendra Pratap Singh versus Padam Kumar Devi. The facts of the case are a client gave power of attorney to his counsel when client was of sound mind. Subsequently, he became old, feeble, weak, unable to comprehend due to mental incapacity. It was held that the power of attorney had become worthless after the change in the state of health and mental infirmity of client. That means a person who don't have the capacity to enter into a contract cannot be treated as principal.